So to start us off, the term amenities in reference to real property valuation refers to A, valuation placed on real property that is the basis for amount of tax levied. B, value of real property established for purpose of computing taxes. C, increase in the value of property either due to positive improvement of the area or elimination of negative factors. Or D, features both tangible and intangible that enhance the desirability of real estate. So the term amenity in reference to real property valuation refers to the what? See? All right. I was actually going to say that too. So actually, it is D. An increase in the value of property, either due to positive improvements in the area of elimination of negative factors, is known as appreciation. Okay, so the one we chose, this is the definition of appreciation. Amenities, including historically desirable location, preferred floor plan, or anything with value to a buyer, enhance the desirability of the real estate. So the both tangible and intangible that enhances desirability. Yeah, that was a tricky one. Which approach to appraisal is best for existing single family residences? Is that going to be A, estimate, B, comparison, C, cost, or D, income? So which approach to appraisal is best for existing single family residences? Right, B, that is correct. Good job. Comparison approach takes into consideration what properties similar to the subject are selling for. Overall is the most accurate approach. Good job. Features that enhance the desirability of real estate are often called A, appraisal, B, assessment, C, opportunity, or D, amenity. Just like question number one. Good job. It is D, amenities. Now we think of desirability and amenities. Good way to relate. And those are features. Good job, guys. Next one. Income capitalization is most likely to be used when the subject property is a single family rental home, B, grocery store, C, none of these answers, or D, apartment complex. D, apartment complex? Correct. Good job. Is exactly right. Okay. The period of time in which a building produces income attributable to the structure itself is its A, effective age, B, economic life, C, functional obsolescence, or D, economic obsolescence. So the period of time in which a building produces income attributable, and I'll say this word, to the structure itself is a, right, the economic life? That is correct. Good job. Good job. Yeah, they try to trick you by doing effective age and economic life. So remember, economic life is a period of time in which the building produces income attributable to the structure itself. All right. Good job. Next question. The assessed valuation of property would best indicate its A, value for listing purposes, B, value for mortgage purposes, C, value for tax purposes, or D, cost replacement value. So the assessed valuation of property would best indicate its what? Your value for mortgage purposes? Oh, right. So it's actually value for tax purposes. And yeah, I was also in between this one. So the assessed valuation property would best indicate its tax value for tax purposes, which then the mortgage takes into place or takes after you figure out the tax for the tax purposes, because the mortgage, you could wrap the taxes into that. The mortgage was a good guess. All right. The income cap technique uses A, net monthly income, B, annual gross income, C, gross monthly income, or D, annual net income. So the income cap technique uses what? Income cap technique uses look back. Yeah, this is a hard one. All right, we say D. That is correct. Good job. So the income cap technique uses annual net income. Nice. All right, the income approach on a single family rental property would use which technique? A, IRV, B, flag method, C, gross rent multiplier, or D, income capitalization. So the income approach on a single family rental property would use which technique? Oh, I like that when I copy and paste question, it gives you all the answers. Oh, I'm just noticing that. A, B, C, or D. Now it's a rental property, a single family rental property. Guesses? All right. Okay, so these are two good guesses. I don't know what the IRV method is or the swag method, but between these two, so gross rent multiplier is best used on a smaller income producing properties. So when this is a single family rental property, that's when you'll use the gross rent multiplier. But income capitalization would be more so like apartment complex, things like of that nature. So yes, that was a good guess. Staff appraisers might be used by a large mortgage company reviewing hundreds of appraisals a year, B, large corporation with many properties to manage, C, both a large corporation with many properties to manage and a large mortgage company reviewing hundreds of appraisals a year, or D, homeowner who wants an estimate of value. So staff appraisers. Now I'm thinking about it. I have done this last week. So what would have staff appraisers who, which business would pay for appraisers to be on their staff? Right. And so we have A. All right. Let's see. Okay. Yeah. C is correct. Staff appraisers are often used by these companies. They're usually paid salary. Cool. So staff appraisers are used for both a large corporation with many properties to manage and any company, a large mortgage company reviewing hundreds of appraisals a year. So they would have appraisers on staff. Good job. An appraisal is the A, support opinion of value, B, value divided by gross income, C, utility, or D, cost less depreciation for age and condition. So what is the definition of an appraisal? All right, so when you think of appraisal, you think that's these guys. So it is actually A. So an appraisal is an opinion of value based on objective evidence and data. So, although they may do value divided by gross income in to get the appraised amount, but the definition of an appraisal is supported opinion of value. Good job. Cool. I went through that pretty fast. All right, so which topic should we do next? Feel free to say it out loud or put it in the chat. Contracts. All right. Well, it's gonna actually this one too. I probably need a refresher on this. Okay, cool. Perfect. We'll do license law after. Thank you. Which is not an essential element of a real estate contract? A, lawful and possible objective. B, good consideration. C, valuable consideration. Or D, offer and acceptance. So which is not an essential element of a real estate contract? Oh, sorry. This is, I accidentally clicked it. I was saying B. Good job. Yeah, that was a tricky one. So B is correct. Good consideration. A contract must be supported by valuable consideration, which is money, real estate, jewelry. Good consideration is usually in form of love and affection, while is not without value. And then contracts must have offer, acceptance, valuable consideration, lawful and possible objective, and competent parties. Just knowing what you need for a contract. So this is going to be key. I had that a lot on my exam. All right. Next question. A large mirror that a buyer wants to remain with the property should. A large mirror that a buyer wants to remain with the property should A, be disregarded as having no consequence. B, be agreed upon verbally with its price stated in the contract. C, never be included in the sales contract. Or D, be identified as a fixture in the sales contract. Right, we have two B's and a D. Let's see. And it is actually going to be D. So be identified as a fixture in the sales contract. And a fixture is defined as a piece of personal property that stays with the real property. So identifying it in your contract as included with the property is going to be the best way to include that in the contract. Yeah, even if it's not attached. So similar compared to that would be like the refrigerator or the washer and dryer or microwave. So if the buyer wants the large mirror to remain with the property, they will put it in as a fixture in the sales contract. Just like they would put if there's the washer and dryer would be included as well. This is kind of a poorly written question because normally with items like this, you would put it on a bill of sale. But for this specific one, how you put it in a contract, that would be the best way to do so. When an offer is presented, the seller may A, accept the offer so it becomes a contract, B, all the answers listed, B, make a counteroffer, or D, reject the offer. All right, good job, guys. All of the answers listed is correct. Good job. Okay, cool. A buyer made an earnest deposit of $500 on a $40,000 house, but withdrew the offer before the seller accepted it. The broker should dispose the buyer's earnest money by A, giving it to the seller, B, keeping it as part of its commission, C, paying it to the court, or D, returning it to the buyer. All right, good job. D, returning it to the buyer. Good job. Since there's no contract yet, there's no need, since there's no contract, since the seller never accepted it, there's no need to take his earnest money. Okay. What is the best explanation of an option? Legal procedure, A, legal procedure or action brought by either the buyer or seller to enforce the terms of contract. B, clause that grants either party the right to cancel the contract provided legal notice is given. C, document involved in closing real estate transactions. Or D, agreement with consideration granting exclusive rights to buy or lease a property at a given price within a stated period of time. Good job. D is correct. And like the answer or the question rationale, an option is a unilateral contract that gives exclusive right to buy or lease property at a given price within a stated time period. So it has to include all of those things. All right. A bilateral contract is one that A, binds both parties to an agreement, B, binds only one party to an agreement, C, is void, or D, unenforceable. And A is correct. Good job. So unilateral, one party, bilateral contract, two parties are involved. Okay. If the buyer in contract for deed, excuse me, sorry. If the buyer in contract for deed, parentheses land contract, who has paid less than 20% of the purchase price default, the seller may A, file a judgment lien, B, wait 10 days and then sell to someone else, C, initiate forfeiture proceedings, or D, initiate foreclosure proceedings. So if the buyer in contract for deed, in contract for a land contract, who has paid less than 20% of purchase price default, the seller may what? Right here, that's correct. Good job. All right. The land contract has been placed for less than 5 years, or the amount paid by the buyer is less than 20% of the purchase price. The seller may initiate foreclosure proceedings 30 days after giving the buyer's notice of default and intent to sell. All right, good job. That was a tricky one. The first instrument a buyer usually signs in a real estate transaction is A mortgage, B listing agreement, C deed, or D offer to purchase. So the first instrument a buyer usually signs. All right, and that is correct. Good job. The correct answer is offer to purchase. So the first thing a seller would sign would be the listing agreement between the seller and broker. But the first thing a buyer usually signs in a real estate contract is going to be the offer to purchase. Okay. The term specific performance refers to A, the right of either party to cancel the contract provided legal notice is given. B, the agreement of all parties of the contract. C, an executed contract in which all elements of the contract have been specifically fulfilled. Or D, a legal procedure or action brought by either the buyer or seller to enforce the terms of the contract. So the term specific performance refers to what? No, this is really also between C and D. I think either buyer or seller could ask for specific performance. And this is when they do, C is when they do follow through with a specific performance. So let's see. All right, yes. So the correct answer is D. So C would be what they once they abided by the specific performance. That is like the end result. But then D is going to be what the specific performance refers to. So a buyer or seller could ask specifically for the buyer to close on this date or the seller to close on this date. That would be an example of specific performance. And that is going to be enforced in your purchase contract. Yeah, good job, guys. That was a tough one. Both of those answers were good answers. Okay. So a purchase and sale agreement stipulates the earnest money deposit be placed in a separate interest-bearing account with any interest earned split between the buyer and seller. This is A, okay, because the buyer and seller have agreed to it. B, against the law. C, not okay, and the broker should resign the listing. Or D, money laundering. Purchase and sale agreement stipulates the earnest money deposit be placed in a separate interest-bearing account with any interest earned be split between the buyer and seller. This is okay because the buyer and seller agreed to it. Against the law, not okay, and the broker should resign. Or D, money laundering. No, this is a tricky question. And it might be B as well. Oh, it was actually A. So it is okay because the buyer and seller both agreed on it. Good job. So it's gone with your first instinct. Good job, yeah. So the law requires that every broker maintain a special non-interest bearing trust account to receive client funds tendered to the broker, and trust, but that does not require that the broker clients use it as deposit. Yeah, that was tricky. So it's okay because the buyer and seller have agreed to it. That remains the best answer. Always gets funky with earnest money. What's against the law is that commingling, the mingling of the money. Correct. In order to have a valid contract, the good faith deposit must be paid in the form of A, anything the party agrees on, B, a personal check drawn on the seller's bank, C, cash money in small bills, or D, a cashier's check drawn on the buyer's bank. Right, we have A, anything the party agrees on. And that is correct. Good job. All right. An agreement of sale is a contract between A, buyer and seller, B, seller and broker, or B, seller and broker, C, buyer and broker, or D, seller, buyer, and mortgagee. So an agreement of sale is a contract between who? We're with buyer and broker. Any other guesses? Agreement of sale is a contract between. All right, we got C, and it is A. So agreement of sale is most often another word for sale contract. It is between the buyer and seller. The listing agreement is going to be between the seller and broker. So agreement, sale, more often called a sales contract, equals buyer, seller. Listing agreement, seller and broker. So once both parties have signed a purchase and sale agreement and the buyer's earnest money check is deposited into the broker's special trust account, whose money is it? A, the buyer's until closing. B, the broker's as a prepayment of commission. C, nobody's until the transaction is either completed, rescinded, or breached. Or D, the seller's until closing. So whose money is it? So once both parties have signed a purchase and sale agreement and the buyer's earnest money check is deposited in the broker's special trust account, whose money is it? A, buyer's until closing. B, the broker's as a prepayment of commission. C, nobody's until the transaction is either completed, rescinded, or breached. Or the seller's until closing. Got C, and C is correct. Good job. So the earnest money is nobody's until the transaction is either completed, rescinded, or breached. And once it is completed, then the earnest money is the buyer's and it goes towards their sale price or their comes out of their closing costs. Right, good job. The law requiring certain real estate contracts to be in writing to be enforceable is called A, statute of frauds, B, statute of limitations, C, written instrument law, or D, parole evidence rule. So the law requiring certain real estate contracts to be in writing to be enforceable is called. Petrofrost is correct. Good job. If the landlord and the area real estate manager of a national real retailer both execute a lease and the corporation fails to occupy the premises, what might prevent the landlord from enforcing the terms of the contract? A, the broker did not have a writing listing, a written listing. B, no corporate resolution granting a signing authority to the real estate manager was approved. C, the real estate manager had authority to make the deal. Or D, the economy declined and the retailer was closing other stores. Area real estate manager, national real retailer. So if the landlord and the area real estate manager of a national retailer both execute a lease and the corporation fails to occupy the premises, what might prevent the landlord from enforcing the terms of the contract? This is a unique question. I guess it, I guess B. All right, I was gonna guess B too. Good job, yeah. So it would be B. No corporate resolution granting signing authority to the real estate manager was approved. All right, good job. Dude, the license law. All right. License law. Okay, license law and rules of Ohio Real Estate Commission. Let's pop in here. Okay. What language does state statute require in a listing agreement? A, full legal description of the property. B, explanation of fair housing law. C, a statement that blockbustering is illegal. Or D, definition of steering. So what language does state statute require in a listing agreement? Is that a full legal description of the property? Which one? Few of these could be correct, but there's one that's the best answer. Okay, that's for A. All right, so it is actually C. Oh, I thought it was B. So C is going to be a statement that blockbustering is illegal. So the agreement must contain a statement that blockbustering is illegal. A full legal description of the property is not required, but only the address. And then the definition of steering is not required under the Ohio civil rights law. But blockbustering is illegal and it must have a statement on the listing agreement. Key thing is listing agreement for this. So that's going to be blockbustering. But definitely maybe on the test. Okay, good job. A broker receives a client earnest money check and deposits it into his trust account. Prior to the closing, however, the broker needs money to pay monthly overhead expenses. He borrows some money from the trust account, fully intending to replace it before the closing. The broker is guilty of A, condemnation, B, misrepresentation, C, conversion, or D, commingling. Kind of mentioned it a little bit earlier. Which one do we think it is? A, condemnation, B, misrepresentation, C, conversion, or D, commingling. And the correct answer is conversion. So conversion is the theft of fund or converting funds for personal use. Commingling is the mixing of trust funds with personal funds and usually occurs inside the trust account. But conversion is going to be the theft of fund or converting funds for personal use. Since he didn't put, even though he is using it for business or personal things, that would be conversion. Commingling is when he mixes the trust account with his personal funds. All right. An agent is advertising his own property for sale. What information must appear in any advertisements that the agent places in the newspaper? A, types of agencies being offered. B, fact that the agent is also the owner. C, any close material relationships between the agent and any potential buyer. Or D, rate of compensation of other brokers. Right, good job. And it's going to be B. They must disclose that they are the owners. All right. Who does an agent need to notify for a change of his or her home address? A, the Division of Real Estate, B, the Commission, C, their local board of realtors, or D, their broker. Who does an agent need to notify for a change of his or her home address? Honestly, probably all these people. But if you best answer would be A, the Division of Real Estate, B, the commission, C, their local board of realtors, or D, their broker. Guesses? Hopefully no guess is a wrong guess. All right, the Division of Real Estate is correct. Good job. So the Ohio Division of Real Estate handles all motion of licenses, including transfers and status changes. So that is who you will need to tell once you're an agent. You need and you move and you're changing your home address, the Division of Real Estate. You can always tell your broker, and we can tell the Division of Real Estate, but you need to because we have to have it in writing. All right. Good job. Next question. A broker and seller agree verbally that the broker will assist the seller in finding a buyer. The broker then finds a buyer for the seller, but the seller refuses to pay the broker a commission. Which statement is true? The seller must pay the commission. B, the broker can recover under the statute of frauds. C, the sales agent can sue the seller for not paying the commission. Or D, the broker cannot recover because the listing was not in writing. So a broker and a seller agree verbally that the broker will assist the seller in finding a buyer. The broker then finds a buyer for the seller, but the seller refuses to pay the broker commission. Which statement is true? Any guesses? So it would be D. The broker cannot recover because the listing was not in writing. So under revised code 4735.18, you don't need to know those things, but states that the listing must be in writing to be enforceable in a court of law. So just make sure you have everything in writing. Key. All right. The principal broker has the following duties except A, oversee and direct operations, B, prepare listing agreements, C, comply with office requirements, or D, comply with fair housing documentation requirements. So the principal broker has all of the following duties except what? We have A is actually going to be B. And the reason for that is B, prepare listing agreements. So principal brokers don't prepare listing agreements. It would be prepared by an attorney, but brokers are the ones who do get executed listing agreements. So that was a tricky one. This one is going to be the principal broker has all the following duties except prepare listing agreements. Anything that has to do with preparing documents or writing up contracts, that is all going to be done by an attorney. Okay. A salesperson asks the broker return her the salesperson asks the broker return her license to the division of real estate so she may transfer to a new broker. The sales agent makes a request in a certified letter, but after 10 days, the broker has not mailed the license to the division. What is true? A, since the broker owns the agent's license, the broker may decide whether or not to return the license to the division. B, the sales agent will lose her license. C, the broker could lose his license for failure to return the sales agent's license. Or D, the sales agent must wait for the broker to return the license. In this case, the salesperson did their due diligence and requested that they that the broker transfers their license and sent a certified letter. So in that case, the broker could lose his license for failing to return the sales agent's license. So under recently enacted Ohio legislations, if a broker fails to return a sales agent's license within 3 business days after a request is made, the broker's license could be subject to suspension or revocation. Oh, it's 3 days. A lot of times you can just do transfers online now. So it's a quicker process. All right. A sales agent is advertising his firm's listed property in a local newspaper. The sales agent must make sure that the A, broker's name appears of equal or greater prominence than the name of the agent. B, agent's name and the broker's name are the same size. C, agent's name and broker's name are the same font. D, agent's name and broker's name are different color types. So between A and B, which one do you think is the correct answer? My guess is, is it? And A is correct. Good job. So you need to make sure that the broker's name is equal or of greater prominence than the name of the agent. Good job. Okay. The closing occurred on September 30th, 2012. Under Ohio's licensing law, the soonest the broker can dispose of the file is A, September 30th, 2019, September 30th, 2014, September 30th, 2015, or December 31st, 2012. So a closing occurred on September 30th, 2012, which is the soonest the broker can dispose of the file. So how many years do we have to keep property in file? Right, we have C, and C is correct. So it's 3 years. So the broker cannot dispose of the file for 3 years from the day of the transaction. It must be advisable to the record longer for tax reasons, but license law does not require. The broker can only to keep files for 3 years. Okay. Good job. Okay. Next question. An auditor appointed by the Ohio Superintendent's Office asked to review a broker's records. What must the broker make available? A, sales contracts but not listing. B, sales contracts and listing contracts, whether sold or not. C, broker's income tax returns. Or D, broker's personal property taxes. So if an auditor appointed by the Ohio Superintendent's Office asked to review a broker's records, what must the broker make available? B, and B is correct. Good job. Right. A buyer makes an offer to purchase a house and gives the seller until midnight, 3 days hence, to accept the offer. Prior to acceptance, the buyer withdraws the offer. What is true? A, the buyer must wait until the end of the 3 days to withdraw the offer. B, the buyer is allowed to withdraw the offer anytime prior to acceptance. C, there is a contract since the buyer made an offer. Or D, the buyer may not withdraw the offer. Right. That is correct. The buyer is allowed to withdraw the offer anytime prior to acceptance. So there is no contract because the seller did not accept the offer yet. So nothing was set in stone. Good job. Buyers make an offer to purchase property and place $1,000 in earnest money into their broker's trust account. The sellers want the earnest money check made payable to them instead. The sales agent should A, write a counter offer stipulating the seller's request. B, not present the offer to the sellers. C, tell the sellers that the sales agent may accept a check made payable to the broker only. Or D, ignore the seller's request as this is illegal and the sales agent does not have to follow an illegal request. What we got there? And A is correct. Good job. So the sales agent is the only person to whom the earnest money check may not be made payable. Other than that, the earnest money is to be handled according to the agreement of the parties. Yeah, that was a tricky one. So a lot of people would answer D, but the correct answer is A. You would write a counteroffer stipulating the seller's request, and before doing anything, the buyers would have to agree to that. Good job. When advertising a listing, a broker offers buyers $2,000 carpet allowance. What statement is true? A, as long as the broker discloses the inducement in the purchase contract, this is perfectly legitimate. B, the seller can sue the broker for fraud. C, this is unethical as the broker cannot offer inducement. Or D, the broker does not need to disclose the inducement because the listing is his and he is not a buyer's broker. So when advertising a listing, a broker offers buyers a $2,000 carpet allowance, which is true. Right. I would also say inducement are unethical and cannot offer, but as long as the broker discloses this inducement in the purchase contract, this is allowed. So as long as he has it in writing in the purchase contract that he's offering the $2,000 carpet allowance, it is he can advertise that. So when it becomes unlawful is when it's not disclosed in the contract. This is tricky because like they only tell you part of the situation and you kind of have to guess the rest. But the statement that as long as the broker discloses it in the purchase contract, it is legit. But yes, that was a great guess. A buyer is going to make an offer on the seller's home. The listing agent says, or a listing agent asks the buyer for $1,000 in earnest money. The buyer does not want to give $1,000 in earnest money, but the listing agent says that this is state law, which is true. Earnest money is set by state law. Earnest money is set by federal law. The buyer must give the $1,000 earnest money. The listing agent is wrong, as there is no state law requiring a minimum or maximum amount of earnest money. Correct, and no amount of earnest money is required by law. Earnest money is negotiable between the buyer and the seller. Good job. A broker receives an earnest money. A broker receives an earnest money payment. The broker deposits the earnest money in his trust account. By law, what is the amount of interest a broker may bear on his trust account? A, the minimum required by state usury laws. B, 10%. C, 0%. Or D, 4%. All right. And we say C, 0%, and that's correct. A broker is not allowed to bear any interest on their trust account. A broker may bear interest on property management accounts, but not a trust account. Well, that's great to know. So broker is not allowed to bear any interest on the trust account. The broker may bear interest on a property management account, but not on the trust account. All right. Next question. A seller and broker agree upon a listing that would pay the broker 6% commission if the broker finds ready, willing, and able buyer for the seller's home. The broker finds a buyer who meets the seller's terms, but the seller refuses to pay the broker's commission. What remedy can the broker pursue? It's going to be A, file a suit for specific performance. B, sue the seller for unpaid commission. C, file a lien against the seller's residence for unpaid commission. Or D, file a complaint with the Ohio Real Estate Commission. So what further action would take place? This is a tricky one. So, correct answer is B. Sue the seller for unpaid commission. No matter how they do it, they just need to sue the seller for their unpaid commission. Broker's liens can be filed by only commercial transactions against commercial real property. So that is not the correct answer. So the buyer can sue the seller for specific performance. So only the buyer can sue the seller for specific performance. Brokers cannot. The broker would sue the seller for the unpaid commission. That would be the next steps. All right. What would be a violation of Ohio licensing law? A, making an earnest money check payable to seller's broker. B, making an earnest money deposit check payable to the buyer's broker. C, making the earnest money check payable to the seller. Or D, making earnest money deposit check payable to the salesperson. What would be a violation of Ohio licensing law? So which one would be breaking the law? Making the earnest money check payable to the seller would actually be making the earnest money deposit check payable to the salesperson. So Ohio law specifically forbids that any earnest money check be payable to the sales agent. Brokers have trust accounts for this purpose. Sales agents do not. So we as agents are not allowed to receive earnest money. The broker is, but the salesperson is not. All right, good job. From where does the real estate licensee get 19 articles of canons of ethics? That A, the Ohio Association of Realtors, B, the National Association of Realtors, C, the Ohio Real Estate Commission, or D, the Division of Real Estate. So Ohio law, oops, I'm sorry, I didn't copy and paste this. So from where does the real estate licensee get the 19 articles of canons of ethics? So, all right, so the correct answer is the Ohio Real Estate Commission. So the Ohio Real Estate Commission is the one where the real estate licensee gets the 19 articles of canons of ethics. Okay, a broker's license could be suspended or revoked for what action? A, offering a free radio to anyone who signs a 5-year lease. B, purchasing a homeowner's warranty for all of his sellers as a marketing tool. C, holding a raffle for a TV for all who attended his open house. Or D, giving a bottle of wine to all clients who bought homes through him last year. So broker's license could be suspended or revoked for what action? All right, so it's going to be A, offering a free radio to anyone who signs a 5-year lease. So you are able to purchase home warranties for your sellers as a marketing tool. You are able to hold a raffle for a TV for everyone who attended in your open house. And then you are able to give a bottle of wine to all your clients who you had a transaction with the previous year. But you are not allowed to offer a free radio for someone who signed a 5-year lease. Making the receipt of the radio contingent upon making a lease commitment is a violation of license law. All right, and last question. Although not mandated by statute, the Ohio Division of Real Estate recommends that for the purposes of document handling and record keeping, A, all agents should have ready access to all files. B, all files be listed on the internet for public access. C, a non-licensed clerical employee should have control of all files. Or D, only the agent who works on a file should have access to the file. So although not mandated by the statute, the Ohio Division of Real Estate recommends that for the purpose of document handling and record keeping. What do they recommend? And the correct answer, the non-licensed clerical employee should have control of all files. All right. Cool. Good job, guys. Thanks so much for joining tonight. I know I probably already gave you, I mean, this is nothing special, but my little CompuCram study guide. Feel free to use it. I know I have Quizlet links in there, and hopefully it's helpful. And I have some of these questions in there as well. I'll try and update it too. Well, thank you. Thanks, everyone. Thank you for joining and thank you for participating. Also, if you have any questions or you're ready to take your exam and schedule it, you just need to um, do the next steps. Let me know and I'll send it your way. My contact information.
Do you know where I can take like the practice test online?
Um, so did you take your classes through Hondros?
Yes.
Okay. They do offer CompuCram
Okay.
online for you to take that. Have you
Okay.
already taken their CompuCram yet?
I believe I have before. I'm not too sure.
Oh, okay. I know it's a bummer. They only let you take it once,
Yeah.
but on my but honestly, if you call them and they have like an in-person one or they're doing a live stream, they'll sometimes just let you hop in or hop on. So definitely touch base with Hondros to see if there is another CompuCram class coming up that you can pop in,
Okay.
or the Quizlets that I actually have linked to my CompuCram study guide. Those are basically CompuCram questions, and you can create like Quizlet into tests for yourself.
All right. Thank you.
Cool. Yeah. All right. Have a great night, guys.